A federal court of appeals rejected an appeal by Donald Trump in Pennsylvania. Welcome to another episode of Legal Briefs. I'm Wes Austin. I'm a lawyer and comedian, and I'm keeping you updated on the latest legal news. So we just got an opinion from the U.S. Court of Appeals for the Third Circuit. Now there are a bunch of cases going on, so let's first identify the case we are talking about. This is a case in Pennsylvania where Donald Trump is a plaintiff along with two other voters. And this is where the district court was Judge Brann. He wrote the 37-page opinion where he referred to the complaint as Frankenstein's monster. That's this one, okay? That went up on appeal to the Third Circuit. The Third Circuit on November 27th issued their opinion. So I did a video on this earlier. I'll put a link in the description. Here's a quick summary. So they were arguing about two different claims, equal protection and the electors and election clauses claims. And the issues they were arguing about were that they said their poll watchers weren't allowed access. And the district court judge had said, hey, nobody had great access, so they weren't treating Republican poll watchers differently than Democratic poll watchers. And then the other one was that they said some counties were able to cure their mail-in ballots and other counties were not, and the district court judge had said, well, that wasn't anything that was directed by the Secretary of State. It just kind of happened in these different counties differently. So those were basically the issues they were arguing about. The district court judge dismissed those. This went up on appeal, and on appeal the only issue was whether the Trump campaign could amend their complaint again. So a very narrow issue was going up to the Third Circuit. Can they amend their complaint again? Now let's look at the opinion. So just looking at a few things on the opinion, again, this is the U.S. Court of Appeals for the Third Circuit. And the plaintiffs on this, Donald Trump, Lawrence Roberts, and David John Henry, against the usual group of characters, including Kathy Bookbar. All right, one thing we should know right out of the gate. Let's look at who the judges were at the Third Circuit, all right? We have Judge Bibas, Shigaris, and Smith, okay? Now, Bibas, the one who wrote the opinion, he was appointed by President Trump, all right? Shigaris and Smith, the other two, they were appointed by George W. Bush. So all three of these judges were appointed by Republican presidents. So here's some language where the Third Circuit basically agrees the narrow issue they're trying to look at. Rather, the campaign appeals a very narrow ground whether the district court abused its discretion in not letting the campaign amend its complaint a second time. It did not. Okay? So, they could be done right there, but they're not going to be done because they have a lot more they want to say, and they're going to say it, you know. You know, like when you ask your dad a question and it's just a very, very simple yes, no, and then he goes off on a bunch of other stuff? That's kind of what happened here. Like if you said, hey, can I borrow the car? And then your dad says, hey, were you not going to cut your hair? And I don't like you hanging out with Robert anymore. That guy is a troublemaker. He just goes off on all sorts of stuff. That's kind of what the Third Circuit did. They were asked a very narrow question and they went crazy on all sorts of other things. Now, interesting, the Third Circuit referred to the second amended complaint, which is weird because they weren't allowed to enter their second amended complaint at the district court. Like that's when the Trump campaign was trying to amend the complaint again, and the district court denied their ability to amend the complaint. So at the district court, they were looking at the first amended complaint. So the Third Circuit's like, yeah, we're actually going to be looking at your other stuff too, because we just want to let you know that the claims you weren't allowed to bring in, yeah, we don't like those either. The Third Circuit, also talking about these other claims, said the campaign tries to repackage these state law claims as unconstitutional discrimination, yet its allegations are vague and conclusory. The Third Circuit also said, nor does the campaign deserve an injunction to undo Pennsylvania's certification of its votes. The campaign's claims have no merit. Ouch. Okay, which claims? Do you mean the claims just in the first amended? Do you mean the claim just, can we amend our complaint, the one thing you were supposed to talk about? Or do you mean the claims in the first amended complaint like the others that weren't on appeal? Or do you mean the claims in the second amended complaint, the one that we didn't actually get entered because the judge said no? Or do you mean just like any claims anywhere? Like the Third Circuit, it seems like the Third Circuit was pretty upset about this whole scenario because making statements like that on things that have nothing to do with the one issue on appeal, they're not happy about this. So on the issue that was actually up on appeal, which was, can we amend our complaint again? The Third Circuit said no, agreeing with the district court judge. And here are some reasons why the Third Circuit said, no, you can't amend your complaint again. The campaign had to plead plausible facts, not just conclusory allegations. Plaintiffs must do more than allege conclusions. Rather, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. The second amended complaint does not meet Twombly and Iqbal's baseline standard of specifics. So here, the Third Circuit was saying amending your complaint would have been futile, which is why it's okay that you didn't get to amend it again. Now, another reason why the Third Circuit isn't going to let them amend their complaint again is this. The campaign has already litigated and lost most of these issues. Many of the second amended complaint's claims have already had their day in court. The campaign cannot use this lawsuit to collaterally attack those prior rulings. So that's another reason why they're not letting him amend their complaint. And the Third Circuit really did not like the remedy they were seeking. Like the district court judge, they thought that there was a huge mismatch between the remedy they were going after and the actual injury that happened. The relief sought, throwing out millions of votes, is unprecedented. Finally, the second amended complaint seeks breathtaking relief, barring the Commonwealth from certifying its results or else declaring the election results defective and ordering the Pennsylvania General Assembly, not the voters, to choose Pennsylvania's presidential electors. It cites no authority for this drastic remedy. Now, just a reminder, this case was not a fraud case. All right, so this is not dealing with fraud. However, there is no clear evidence of massive absentee ballot fraud or forgery. On the contrary, at oral argument in the district court, the campaign specifically disavowed any claim of fraud. Okay, it's important to note that because there have been a lot of things out on the news out there about voter fraud. And this case specifically was not about voter fraud. Voters, not lawyers, choose the president. Ballots, not briefs, decide elections. What about Bush v. Gore? Never mind. That'll take too long. Seeking to turn those state law claims into federal ones, the campaign claims discrimination, but its alchemy cannot transmute lead into gold. Now, somebody's really proud of themselves about this cannot transmute lead into gold. Probably a clerk that works in the Third Circuit. Nice job. So the Third Circuit rejected the Trump appeal, and in their rejection, they really took him out to the woodshed, and they were not happy about anything that was going on, basically. Will the Trump campaign try to appeal to the U.S. Supreme Court? They could. I highly doubt that the U.S. Supreme Court would take this up and review it. I mean, the issue on appeal is just, did the district court judge abuse his discretion in not letting him amend their complaint again? I can't imagine the Supreme Court would think this is an important issue that we need to take up. So it's, super slim chance that the Supreme Court will review it. All right, thanks for watching, and I will try to keep you updated on any other legal news.